So the executive is subject to an increasing number of legal frameworks, including the FOI Act, the Human Rights Act, judicial review, and European law. And when we think about compliance with all of those frameworks, we usually think about the courts. That makes sense within the UK Constitution because the courts are the ultimate arbiters of what the law means. But in fact, most of the legal issues that are dealt with by the executive are dealt with within the executive. They're determined usually by government lawyers. So my idea was to go around and interview a small group of government lawyers and some of their clients and ask them what they were doing when they were giving legal advice. Government lawyers are basically civil servants who have a professional legal qualification and work in a legal field within the executive. The biggest group of government lawyers are probably in the Crown Prosecution Office, but I wasn't looking at them. I was looking at a very specific group of government lawyers, the ones who give advice to ministers. The biggest group really within Whitehall is the Government Legal Service, and there are about 2,000 of them. Within that group, there are probably 800 who are located within the Treasury Solicitors Department. And outside of that, there are also lawyers in executive agencies, but also in regulatory agencies. And then there are some who actually don't belong to the Government Legal Service at all, like the lawyers in the Foreign Office and also in the Office of Parliamentary Counsel. Legal advice is basically provided on a departmental basis and given to ministers. And the reason for this is that under our constitutional system, the people that are legally empowered to make decisions in government and those who are constitutionally responsible for making those decisions, it's not the Prime Minister and it's not like government, but rather secretaries of state. So legal advice follows that constitutional line of responsibility. So that might create some problems if you think about it. If legal advice is given to departments, how do lawyers in departments ensure that the advice that they give is consistent with the advice they give in other departments? And there are really two answers to this. The first is that there are a number of coordinating bodies. For instance, Cabinet Office deals with European Union law. Oddly, the Foreign Office deals with Strasbourg jurisprudence. And for instance, the Office of Parliamentary Counsel deals with the specialists dealing with the drafting of primary legislation. The other way in which this is dealt with is through a legal hierarchy. There's actually a hierarchy of legal advice within Whitehall. So at the top of this apex is the law officers, so the Attorney General, the Solicitor General, and the Advocate General. And if there's a real conflict about legal advice within a department or between departments, or there's some issue which has major constitutional significance, this may ultimately end up going to the law officers. And they're understood within Whitehall to be the final arbiters of how the law should be understood by the executive. There are also a number of intermediate kind of bodies or individuals who also help with this. For instance, the Treasury Solicitor, who is the Permanent Secretary in the Treasury Solicitors Department, and also, perhaps more importantly, First Treasury Counsel, formerly known as the Treasury Devils. And there are two of them who work in the civil law area, so they mostly deal with public law issues. And they are the top government litigators. And as the top government litigators, they are best sort of placed to understand the legal landscape, and they're best placed to ensure that there is consistency across government. In the past, government lawyers tended to be involved at a very late stage in the policy-making process. And the kind of legal advice they would give would be even sort of supervisory, almost like a judgment. Nowadays, government lawyers are involved in a very early stage in the policy-making process. And they're more likely to see their role in giving legal advice as being about legal risk. And this has happened for sort of a bunch of reasons. The first is technology. In the past, what would happen is policy would be worked up, and probably near the very end of that policy-making process, a bundle of papers which constituted the policy would be sent to government lawyers. Now they just get emailed in. They're CC'd in on the very early stages of any policy, and they can give their comments. The second reason is that law is just now more sort of omnipresent. It's everywhere, and so lawyers just have to be involved at early stages of the policy-making process. And it's not just that law is more omnipresent, it's more complex. For instance, nowadays it may be the case that government lawyers may be asked, for instance, to look at a proposed course of action and ask whether or not that is proportional under the Human Rights Act. And so it's very difficult for them to give certain legal answers. They're more likely to couch things in terms of risk. The final reason why, I guess, government lawyers and their role in the policy-making process has changed is not really government lawyers themselves, but the opposite, really. Their colleagues' role in the administrative process has changed. That is, I'm talking here about generalist civil servants. Generally speaking now, generalist civil servants have a much higher turnover rate or a shorter time in office, and the kind of skills that are required of generalist civil servants have changed. In the past, the very traditional kind of policy skills that were required were policymaking skills. Now the skills that are required are more about delivery and management. Okay. I think probably the ones that I interviewed wouldn't see it that way. They would prefer to see themselves as both officials and lawyers. And in their role as officials and lawyers, their job was to help the minister within the framework of the law. And arguably anyway, there's no conflict between being an official and being a lawyer. The Civil Service Code is very clear that all civil servants must comply with the law. And government lawyers have their own guidance note, which we set out in our report, which sets out their responsibilities and roles. And if there are issues about the legal advice that they're given, there is a process which can be followed, one of which is to send that legal advice up through the legal hierarchy that I was talking about. Having said that, most government lawyers did think that they were different from private sector lawyers in the way they approach the law. For instance, for them, government lawyers, they would think more about issues such as vires, the powers under which governments acted. They also had to take into account the public sector context law. So, for instance, a proposed course of action might be legal, but it might not necessarily be prudent. And they had to take into account the role of Parliament. If Parliament didn't like a proposed course of action, I think government lawyers would probably tell the minister that such a course of action was not appropriate.